In this first lecture, we're going to explore the connections between ethics and politics and healthcare law. The orthodox view of healthcare law scholars is that we should expect the content of healthcare law to be closely related to ethics. And one of the key figures in the development of medical law, Sir Ian Kennedy, adopts an approach which elsewhere I've called ethical consumerism, which suggests that the purpose of the law is to try and protect consumer rights in accordance with medical ethics. Now, I shall try and explain why I think this is a difficult approach to sustain if you think it's a description of healthcare law. This is because much of the law that we have isn't actually designed for healthcare purposes, and we've discussed that in relation to the end-of-life care issues. I shall also explain how I think that going to court requires people to fit their ethical reasoning into the legal categories before they can make their claims. And a good example of that is the case that went to the House of Lords in relation to human cloning and whether it came within the human fertilisation and embryology legislation, one of the Quintabelli cases. Thirdly, I think the actual examination of the law suggests that the connection between the legal rules that we have and the moral foundation is often surprisingly tenuous. And you can see an illustration of this when we think about how the law of consent works, for example in relation to research where consent forms have become a way of transferring risk to the research participants and away from the drug companies, or in relation to data protection where you can waive your rights by agreement and enable information to go out of the European Economic Area. And finally, it's fairly clear that the law departs from what people think the right ethical position should be in a number of cases. It's also difficult to explain the connection between ethics and law if what we look at is the way in which law is made, when healthcare law is produced. And a very interesting suggestion about how we might connect ethics and law was made by Derek Morgan and Bob Lee in what they called the theory of stigmata cases. This is the idea that when litigation happens in relation to medical issues, it brings to the surface the fundamental value conflicts of our society. But when you look at that in relation to the cases that they use, in particular that of Diane Blood, it seems hard to explain this as a theory of how ethics drives the law. Because in that case, the legal rules, both in the decisions about the Blood case itself, when they looked at whether or not Diane Blood could lawfully retrieve the sperm of her dying husband, and also at the policy that followed it in relation to the maintenance of written consent as the key legal rule, you see a divergence between what seemed to be the public view of appropriate ethics and what happened in law and policy. And then when you're thinking about how law is made, you have to remember that judges frequently say that they are judges in courts of law, not courts of morals. So they deny the connection between ethics and law in many cases. Although if you read our work on hidden lawmaking, you can see that it's not quite as simple as that. It's actually much more complicated. And then you have the problem in lawmaking about how you move from case-specific judgments into general ethical principles. And the points made in the Court of Appeal in Nicklinson about how careful the court should be about taking on the roles that are usually dealt with as being part of Parliament. And then when you turn to Parliament, it's often the case that the decisions that Parliament make seem to be more driven by responses to politics and political scandals than they are to careful ethical reasoning. And you can compare the way in which the human fertilisation and embryology legislation was developed, which seems like a good attempt to work out the ethical principles and implement them into law, with the responses to scandals and the way in which the human tissue legislation at various stages has been developed, most recently in the Human Tissue Act of 2004, which responded to a political scandal in Liverpool and led to a reliance on consent, which can partly be justified by ethical principles, but can't fully be explained in those terms. And then you see what are very clearly responses to moral panics in legislation like the Surrogacy Arrangements Act of 1985. And finally, in relation to the way in which law is made, it's far from clear whether there is really any consistent underlying set of principles that give coherence to the area of law. something which Ian Kennedy claimed and which we'll look at in one of the later lectures. So this sort of analysis had led me to develop what I describe as the demoralisation thesis, in which I suggest that there's in fact no real link between our current law and ethics. And secondly, that if we seek to use the law more to regulate healthcare practice, we actually discover ourselves distorting ethical issues rather than resolving them. And thirdly, that if we do that, we don't just fail to resolve the ethical issues, but we positively undermine medical ethics. And I suggested that the orthodox view was overly dependent on adopting a technocratic view of medicine, that it was the appliance of science, rather than the recognition of the value-based practice of a professional community. I also argued that it fitted much better a market-based, rights-based health system and didn't sit very well with the socialised state-provided system of the National Health Services in the UK. It seemed to me that the approach that most judges took was based on the assumption that they were seeking to reinforce professional values and integrate professional ethics as part of the legal normative system, rather than to see the two in opposition. And I identified in a paper called Law and the Demoralisation of Medicine that things were perhaps changing under the stewardship of James Mumby, and certainly that seems to be the sort of thinking that lay behind the Supreme Court's approach to informed consent in Montgomery, which we've discussed, and which, as you know, I think doesn't display a very careful grasp of what's at stake in terms of medical ethics. Now, the idea of the demoralisation thesis in some of its aspects has been widely accepted, but the suggestion that we should see a solution to that in terms of greater integration of professional ethics and law has been powerfully criticised by Jose Miola on the basis that it undermines the very idea of the rule of law. So in the second lecture we shall explore the claims that need to be met if we are going to say that healthcare law properly addresses rule of law requirements.